The changes targeting illegal entry, the new policy introduces another disqualifying criterion for applicants. It specifies that individuals who arrived in the UK through what the policy describes as a dangerous journey, such as crossing the channel in a small boat or hiding in a vehicle, will also face refusal of British citizenship. For many refugees, these dangerous routes are their only option to flee persecution or violence in their home countries, as safe and legal alternatives are limited. Critics argue that the new policy disproportionately affects vulnerable refugees who cannot meet traditional entry requirements. A coalition of human rights organizations and immigration lawyers has brought the legal challenge, citing violations of the 1951 Refugee Convention. The Refugee Convention is an international treaty that outlines the rights of refugees and the obligations of nations to protect them. Article 31 of the treaty prohibits the punishment of refugees for entering a country illegally, provided they present themselves to authorities promptly. Article 34 requires signatory states to facilitate the naturalization of refugees. Legal experts argue that the UK's new rules breach both of these provisions. This claim will form the basis of the legal arguments presented in court. The Home Office has publicly defended the policy, stating that it is a move to deter illegal immigration and ensure that British citizenship is granted only to individuals who have respected UK laws. Critics, however, strongly contest this justification. They argue that the new rules will likely fail as a deterrent and serve primarily to punish people who are already in the UK, some of whom have been living in the country for years or even decades. Activists contend that it unfairly creates a permanent group of non-citizens who are marginalized regardless of their length of residence in the UK or contributions to their communities. Prior to these changes, applications for British citizenship involving illegal entry were assessed on a case-by-case basis. Officials could choose to ignore the issue if the breach occurred over 10 years before the application. The new policy removes this option, applying these changes retroactively to past cases. Critics have labeled this approach as a form of retrospective punishment, which is heavily restricted under UK law and widely regarded as unjust. The legal challenge has already gained significant support from refugee advocacy groups, immigration lawyers, and political figures. Many of these voices claim that the updated policy contradicts the UK's long-standing reputation as a safe haven for those fleeing conflict or persecution. Refugee organizations have highlighted that the rule particularly targets those who had no safe, permissible means of finding entry into the UK, leaving them effectively barred from ever becoming full members of British society. A key issue being raised in the legal action concerns the lack of proper public and parliamentary oversight in the adoption of the new good character policy. Detractors argue that such substantial changes should have been debated thoroughly within Parliament and subjected to public consultation. This absence of scrutiny has added fuel to complaints that the revisions were rushed through without adequate consideration of their potentially profound impacts. The case represents one of the most significant legal challenges to UK citizenship policy in recent years. If successful, the High Court could force the Home Office to revise or even roll back these controversial provisions. However, even if the High Court rules in favor of the Home Office's stance, this legal battle is expected to ignite wider debates about immigration laws, refugee protections, and citizenship criteria in the UK. The implications of this process are likely to attract international focus, particularly from countries and groups concerned with human rights and legal protections for refugees. Practical aspects of the policy have also raised eyebrows. For example, the current fee for a British naturalization application is £1,630. Critics argue that refugees may now hesitate to submit applications, given the high likelihood of rejection under the updated guidance. This financial risk could discourage long-standing residents of refugee backgrounds from even attempting to gain citizenship, reducing their ability to participate fully in British society. The policy shift is seen as part of a broader effort by the British government to tighten immigration enforcement and restrict access to citizenship. Over recent years, a series of measures aimed at reducing unauthorized immigration have increasingly limited pathways to legal status or naturalization for refugees and migrants. This has led some commentators to describe these steps as a departure from the UK's traditional support for humanitarian principles. Another significant consequence of the policy has been widespread discussion about the lack of safe and legal routes available to individuals seeking asylum in the UK. Advocates argue that unless accessible pathways are provided, asylum seekers will continue to take dangerous journeys that render them ineligible for citizenship under current rules. The government's stance has thus reignited calls for introducing structured, legal entry mechanisms for refugees to address the root causes of the dangerous crossings that the policy seeks to penalize. As the case moves closer to the High Court, the tension between the UK's international legal obligations and its domestic policies has become increasingly evident. The Home Office has emphasized its commitment to robust immigration controls, while the opposition has pointed to the principle of fairness and adherence to international law as paramount. Observers are watching closely to see the legal challenge's outcome, as it could help shape the direction of future UK immigration and citizenship policies.